afternoon, and welcome to your Construction Safety Association of Manitoba's 2025 virtual webinar series. My name is Megan Story, and I am the Training and Development Manager of the Construction Safety Association of Manitoba. We are proud to be recognized as your premier and trusted source for safety and health information, resources, training, and core certification. Today's virtual webinar is an example of how we are striving to provide you with practical and relevant information to help with accident prevention in your workplace. For those of you who know CSAM, quite simply, our answer is yes. How can we help? We will give you, or we will have the answers to your safety questions, or we will find the answer with the help of our qualified resources and partners in safety and health. Today, I am pleased to introduce John from Workplace Safety and Health. In today's webinar, John will provide a focused overview of the recent changes introduced in Bill 29 with a specific lens on the construction industry. From updated compliance obligations to enhanced enforcement strategies, this session will help you understand how the amended legislation affects your day-to-day operations, job sites, and safety responsibilities. We have had an overwhelming response to today's webinar, and with over 300 registrants. Therefore, questions will be answered at the end of John's presentation. We do, however, welcome you to add your question in the question and answer or the Q&A section of the webinar, which you can find at the bottom right-hand corner of your screen. So please add your questions throughout the webinar. Please note that this webinar is being recorded and a copy of John's presentation will be made available. At this time, I will pass this off to John. And John, the screen is yours.
Good afternoon, everyone. 300 people, that's really good. I'm glad I'm just sitting here in my nice little cube here, getting prepared for this presentation. So my name is John. I'm with Workplace Safety and Health. I've been here since 2020. I'm currently in the Incident Response Unit, which is the unit responsible for attending serious incidences. Prior to that, I was with the Inspection Services Unit, doing inspections and proactive work. I was asked and I volunteered to assist in this presentation of Bill 29, the Workplace Safety and Health Act, or Health Amendment Act, to provide an overview to CSAM and their stakeholders. Like Megan says, we will be answering as many questions as possible at the end of the presentation. However, if I cannot answer the question, I will record it and do my best to provide the answer to you at a later date. The presentation I will be providing today was created by our policy team with the focus of CSAM in mind. So hopefully you get something from this. And I'm going to start my presentation right away. I hope everyone can see this because I can't see anybody. All right. So I just want to let everyone know that my comfort level for presenting is in a room with a bunch of real people and getting to see people's expressions and their faces and seeing their engagement. Doing the presentation this way and virtually is fairly new to me. So if I do kind of stumble around, please bear with me, but I'll do my best to provide the information. Okay, so today we're going to be speaking about Bill 29, the Workplace Safety and Health Amendment Act. So as part of our obligations, we're going to do a land acknowledgement. We acknowledge we are gathered on Treaty 1 territory and that Manitoba is located on the treaty territories and ancestral lands of the Anishinaabe, Anishinaabeg, Dakota Iote, Diné, Sula, Ne, and Nihathu-Wook nations. We acknowledge Manitoba is located on the homeland of the Red River Métis. We acknowledge northern Manitoba includes lands that were and are the ancestral lands of the Inuit. We respect the spirit and intent of treaties and treaty making and remain committed to working in partnership with First Nations, Inuit, and Métis people in a spirit of truth, reconciliation, and collaboration. Safety is everyone's responsibility. Every year, more than 1,000 Canadian workers are killed because of the job. Hundreds of thousands more sustain physical or psychological injuries because of unsafe working conditions. At Workplace Safety and Health, our mission is to improve compliance with the Workplace Safety and Health Act to prevent occupational injury, illness, and death. 2022-2024 Workplace Safety and Health Act Review. The Workplace Safety and Health Act mandates the review of this act at least once every 5 years. In August of 2022, the legislative 5-year review of the Workplace Safety and Health Act was launched, and the Workplace Safety and Health Act Review Committee was established, comprised of equal number of labor, employer, and technical representatives. The review committee was tasked with undertaking the legislative 5-year review of the act and deliver consensus recommendations. The minister's mandate for the review committee included ensuring that strong protections are in place that meets the need of today's workplace, improving harmonization and consistency with other jurisdictions, ensuring requirements are clear and reasonable, and helping Manitoba meet its obligations under the Regulatory Accountability Act, aiming to reduce red tape while ensuring regulations serve the public interest effectively. Public consultations were held with 3 months of public consultation, which resulted in 62 submissions containing 197 unique recommendations from Manitobans. The following is a timeline of the act itself and from when it started to completion. So the review committee conducted its review session from January 2023 to December 2024. During this period, the committee members evaluated the public submissions, considered relevant legislation and information from other jurisdictions, and analyzed Manitoba-specific information to develop recommendations for each submission. The Workplace Safety and Health Act review recommendations were shared with the minister in January of 2025. Bill 29 was introduced on March 6th. The bill proceeded to its second reading on April 17th. It reached its third reading on June 2nd, and finally on June 3rd, 2025, the bill received royal assent, bringing into force 17 amendments to the Workplace Safety and Health Act. So for today's presentation, the focus is on the following 10 amendments, which from our policy team, previous presentations to other stakeholders, we did identify this would be the most relevant for this group. Now, from the list, as you can see, we'll be talking about psycho safety in the workplace, right to refuse, medical surveillance. What's not going to be presented today, but I will cover just right now, is the following from the amendments that were approved and now are part of the act. So one is maintaining workplace safety health jurisdiction to hear reprisals in unionized workplace as a result of a court case back in 2021, I believe. There was questions about who has jurisdiction on a unionized workplace when it comes to hearing reprisals. The act was changed to ensure that workplace safety health continues to have that obligation and authority to hear reprisals even in a unionized workplace. Another one that's not being discussed in length is allowing employment standards to select unpaid wage amounts owed to workers due to reprisal. So it's an opportunity and a tool that we can use if an employer was found that a reprisal did occur and that quantum formula for what is owed is not being paid. We have the ability to ask employment stores for assistance in collecting. Third one is remove reference to the type of materials to be provided for Manitoba Labor Board referrals. What that means is that IRU and other departments have started using technology such as video recording, audio recording to collect information. Prior to the changes, it was clearly indicated about written material. Now that we're going towards more audio and video, we had to amend the act to incorporate those changes to our practice. Allow Manitoba Labor Board to able to decide an appeal without an oral hearing. So prior to starting this presentation and agreeing to do it, Megan and I had a conversation about questions that were being asked about the bill. So a list of questions were provided me. One question was about deciding an appeal without oral hearing. So I just want to clarify that Manitoba Labor Board will continue to have oral hearings and written statements as part of their process to determine what occurred and make a position. So it just expands the opportunity for us or for Manitoba Labor Board to have different avenues of information being collected. Allow Manitoba Labor Board to require one party to pay costs of another party on an appeal. So Manitoba Labor Board, if they find that the complaint or the concern brought to them was frivolous and vexatious, they have the ability now to make that party pay for the cost of the hearing. Um, Workplace safety and health jurisdiction over matters raised in multiple forums. So with that, it's workplace safety and health has the ability now to deny hearing a concern if the individual has looked at other jurisdictions or agencies such as labor board, human rights, if they're trying to get an answer. So we're ensuring that we're not overstepping and that they're not trying to put one agency against the other and to make a decision. And one of the last ones here is require recipient of order to provide documents to safety and health committee rather than the officer. So that change was made as previously safety and health officers were required to provide documentation not just to the employer, but also the safety and health committee if one's present or a safety rep. That eliminates because it's duplicity. We found that workers or employers have been providing those types of reports to the safety committees or the safety rep for their attention. So those are just some cleanups that we've done with the act. And I just want to reiterate that the conversation today is focusing on the act and not regulation. Okay, so number one, psychological safety in the workplace. From the list of questions, majority of questions were focusing on psychological safety in the workplace. We fully understand that it's newer, and that at this point, what we've focused on is the definition of psychological safety. So I'm just going to read this out. Enabling workers to work in a psychologically safe workplace has been added to the objects and purposes of the Workplace Safety and Health Act. The Act states that a psychologically safe workplace is a workplace in which the psychological well-being of workers is promoted and active measures are undertaken to prevent harm, whether negligent, reckless, or intentional, to the psychological well-being of workers. Psychological health and safety related regulations are anticipated in the near future. This description of a psychological safe workplace aligns with the 2013 Canadian Standard Associations of Psychological Health and Safety in the Workplace. So their definition. So just to add to that, guys, is that first off, Manitoba was the first jurisdiction in North America to adopt a reference to psychological safety in law. The first country was Australia back in 2022. So from the questions that I read about psychological safety, a lot of the questions were about the how to, or how do you determine psychological safety? How far do you have to go? What is compliance? Now, we're not at that point. What we're at the point right now is that we provided a definition specifically about psychological safety. I've had conversations with management. I've had conversations with policy. And what I want to say to you right now is that this psychological safety definition, this does not focus on the mental health of workers. The focus of psychological safety within the employer's sphere of control, which is the work environment, or the work itself introduced a hazard or potentially introduces a hazard. Now, questions were asked about what tools can we expect or where can we get information about this? So if you check out Safe Work Manitoba on their website, there are numerous courses, some free, with a fee that deals with psychological safety that can assist you in developing your program and melding it within your safety culture and into your safety program at work. So there are tools out there right now. Now, my understanding is that Safer Manitoba is still creating more tools for measurements, for training, things that's going to help our stakeholders. So my recommendation is just keep an eye on what's going on with Safe Work Manitoba on the website. You're more than welcome to contact our executive, Crystal Baldwin, if there's any questions about that. But at this time, our focus is just on the definition of psychological safety. In the future, like I said initially or previously, there will be regulations, and currently they are doing a draft of it, and um, I do not know when that will be done, but it'll follow the same process as this amendment of the act. Okay, right to refuse dangerous work. So under Workplace Safety Act, a worker may refuse to work or do particular work at a workplace if they believe on reasonable grounds that the work constitutes a danger to their safety or health or to the safety or health of another worker or another person. A new section on interpreting dangerous work in right to refuse has been added. This is to help ensure that the right to refuse dangerous work is understood and applied consistently. It clarifies that dangerous work is a situation where there is an imminent risk of serious physical or health injury and where adequate controls have not been implemented. This section acknowledges that a hazard may present more of a risk to certain individuals, therefore additional measures may be needed in some circumstances to protect workers. So the addition of this definition reflects the current public education material that is provided to the public and our stakeholders. During COVID, numerous educational material talking about dangerous work and what is considered dangerous work was provided. The definition being added focuses on the hazard as imminent to a person's health or exposure to a serious injury. Medical surveillance. So medical surveillance involves monitoring the health of workers through tests and examinations to identify possible health problems related to occupational duties or exposure to hazards. For example, depending on a type of exposure, medical surveillance may include hearing tests, lung function tests, blood tests for lead or chemical exposures, and chest x-rays. Previously, medical surveillance programs were only required in the mining industry. Now, the COMO authority has been expanded to order an employer to implement and maintain a medical surveillance program in workplaces where workers are suspected of being overexposed to a harmful substance such as asbestos, lead, or etc. Now, from my review, to add to medical surveillance, the COMO itself won't just randomly pick anything or any type of concern that they see. It has to be supported to them. They need evidence that suggests that there could be an exposure and that they have now the ability to have the employer do testing. The employer also has the ability to appeal this if the COMO goes to that direction. So there are checks and balances to ensure that the employer has the ability to say, you know what, wait, what does this mean? Give me a little more information. Why are we doing this? So that's already built in. So it's not where the COMO on a whim says, hey, let's start checking for chlorine in this area. That's not the intent of it. The intent of it is just to open up the ability to do more surveillances concerning exposures. So if new information becomes available after an order is made, the chief occupational medical officer may reconsider the order. The procedure for reconsidering an order is determined by the COMO. If the COMO collects any personal health information about a worker under health surveillance programs, that information must stay confidential and cannot be shared with anyone else unless the law requires it to be shared. The information is shared in a way that doesn't identify the person or the person gives permission for it to be shared. Related employers treated as a single employer. So Workplace Safety and Health has encountered some employers who change names in an attempt to evade enforcement or penalties. For example, instead of complying with an order or addressing a hazard, the employer may choose to close the business and reopen it under a new name. Often, the new company has the same directors and shareholders, operates in the same business sector, and does similar work. To address this challenge, the new amendment allows a director or the Manitoba Labor Board to be able to deem associated or related businesses carried on under common control or direction by two or more employers to be a single employer for workplace safety and health purposes. This applies whether or not the businesses are carrying on work at the same time. The new authority would allow these employers to be held accountable by addressing instances of repeat noncompliance of a similar nature. Electronic delivery orders. A safety and health officer may issue an improvement order or a stop work order to the employer. An improvement order is a written direction order to address a situation where a workplace safety and health law is being broken. It will explain what is wrong and what the legislation requires to comply. It will also tell you the date by which you must comply. When a safety and health officer observes an imminent risk and hazard, they may order work to stop immediately and remain stopped until they are satisfied that the hazard is appropriately dealt with. Previously, improvement or stop work orders could be communicated by delivering a copy directly to the person or the agent, sending it by registered mail, or if those methods fail, posting it in a conspicuous place or at a near or near the workplace. So what this does is this clarifies that emails or other electronic means are valid means of service delivery for improvement orders and stop work orders, generally as opposed to requiring director approval for each instance. The Act amended introduced and clarifies electronic methods for communicating orders. The Act states that if person or their agent has provided an email address or another electronic method of communication, the order can now be sent electronically. Furthermore, the Act states that an order sent via electronic means is deemed received on the date it is sent, unless the sender receives an automated response indicating the message was undeliverable, or the recipient had previously informed the sender in writing that the email or communication method should not longer be used. Posting of orders. Previously, the Workplace Safety Act stated that if an improvement order or stop work order cannot be communicated by the standard methods, the safety and health officer is responsible for posting a copy of the order in a conspicuous place or at or near the workplace. There is no requirement for how long the order had to remain posted. Current legislation states that if the improvement order or stop work order cannot be communicated through the standard methods, the safety and health officer may post a copy of the order in a prominent place or at or near the workplace and keep it posted there for 7 days or until compliance with the order has been achieved, whichever is longer. So with that, we're looking at 7 days at minimum or when it's complied. The workplace safety law requires a person against whom an improvement order is made, example, employer, to prepare a written report on measures taken or to be taken to remedy a contravention. Previously, the Act required that if no committee or representative exists in the workplace, the person subject to the improvement order is responsible for posting the report in a prominent place at or near the workplace. The duration of keeping the report posted was not specified. The current legislation states that if there is no safe and health committee or worker safe and health representative for the workplace, the person whom an improvement order is made shall post a copy of the report in a prominent place at or near the workplace and keep it there for 7 days or until compliance with the order has been achieved, whichever is longer. So this just clarifies our steps that we would take. So if there is a safety committee, if there is no safety committee, no safety rep, we would have the employer be responsible for posting. Competent risk assessments. Risk assessments are a vital component of ensuring workplace safety and health. If risk assessments are not conducted effectively, hazards may remain unaddressed, posing a risk to the worker safety and well-being. The new legislation states that whenever a risk assessment is required in any context within the regulations, it must be conducted by a competent person. The Workplace Safety and Health Act defines competent as possessing knowledge, experience, and training to perform a specific duty. The intent is to ensure that potential hazards are effectively identified so they can be mitigated to prevent workplace illnesses, injuries, and fatalities. Administrative penalty for failure to report serious incidences. So workplace safety and health regulation outlines the definition of a serious incident. A serious incident is an incident in which a worker is killed, in which a worker suffers an injury resulting from electrical contact, unconsciousness as a result of a concussion, a fracture of his or her skull, spine, pelvis, arm, leg, hand, or foot, amputation of an arm, leg, hand, foot, finger, toe, third-degree burns, permanent or temporary loss of sight, a cut or laceration that requires medical treatment at a hospital as defined in the Health and Services Insurance Act, asphyxiation or poisoning, the collapse of a structural failure or of a building, structure, crane, hoist, lift, temporary support system or excavation, an explosion, fire or flood, an uncontrolled spill or escape of a hazardous substance, or the failure of an atmosphere supplying respirator. Under the workplace safety and health regulation, when a serious incident occurs at a workplace, an employer is required to immediately and by the fastest means of communication available notify the workplace safety and health branch. The new amendments outlines failure to report serious incidents or provide the required information respecting a serious incident in accordance with the regulations, which may result in the issuance of an AP. Now, I'll just kind of add to this right now. If an employer fails to report a serious incident to us, this is not the first step we'll do. We will provide education. We will definitely issue an improvement order to remind you that it is a requirement under our act to provide information of a serious incident in a timely manner. We would definitely want to build that relationship with the employer to ensure that going forward, if they do experience another serious incident, that it is reported to us. Now, if it is a reoccurring concern that they're not reporting, we now have the ability to put an administrative penalty, and they do range from 1,000 to 5,000 based on the officer's position and discretion of how the employer is responding to the requirement of reporting serious incidences. So we'll always try to work with our stakeholders to provide education, trying to promote to be compliant with this. However, if that doesn't happen, we have this as a tool. Okay, so one of the things that we were doing is replacing accident with incident. The Workplace Safety and Health Act has been amended to replace the word accident with incident. Terminology of accident implies an event that is random or unavoidable. However, incidences in the workplace are preventable. By recognizing that incidents are not inevitable, the law promotes better risk assessments, stronger preventative measures, more accountability for safety practices. Seasonal and temporary workplaces. Previously, the Workplace Safety and Health Act stated that employers are required to set up a safety and health committee if they have 20 or more workers at a seasonal workplace for a period of 90 days or longer. The review committee suggested the term seasonal could be misinterpreted. This is because some employers may assign additional workers not due to calendar seasons, but due to factors such as particular work orders or increased work volume. This is unrelated to seasons. The amendment clarifies that this rule also applies to other temporary workplaces, not just seasonal ones. So if a temporary job site has 20 or more workers and lasts 90 days or more, a safety committee is required. These amendments ensure that temporary workplaces are held to similar safety standards as seasonal ones, improving work protection across more types of work environments. So at this time, I've come to the end of this presentation of Bill 29.
Yes, thank you so much, John. I appreciate all the time that you have put into answering those questions, and thank you to everyone that attended today with all the questions that you did have for John. As John did mention, there are some questions that he will be looking into responding to, and we will be sure to share those responses to everyone that is registered for today's webinar. Thank you, John, again for your presentation and everyone for attending today. We have recorded this presentation. We will work to have this posted to our YouTube channel, so please watch this space. I will make sure that that gets to you in a timely fashion, as well as an opportunity for you to provide comments or feedback on today's presentation. We do strive to ensure that we are providing really excellent information and resources to our members, and this is just one opportunity that we are doing that. So thank you everyone for attending today. Please watch your emails for updates on this webinar. And once again, thank you, and we'll talk soon. Bye-bye.